Okay, the title of this lecture is Introduction to Criminal Justice Perspectives. I'm going to give you a few broad ways to look at the criminal justice system, but this is a picture of Lady Justice, and this is the ideal of our criminal justice system. So, our justice system is supposed to, she's holding a scale and she has a, which is not a headband, what's that called? You know, the thing, blindfold. So Lady Justice is blind. All she does is weigh the scales of justice, meaning the evidence impartially. And then that little sword, I guess, is sort of this, like if you do wrong, you're going to get stabbed by the justice system. But this is one of the ideals that will relate to one of the perspectives we're talking about. There are other sort of perspectives that think this idea is a joke, right? That the justice system is impartial and blind to who you are, etc. Right, next slide. Okay, I'm going to talk about the elements of the criminal justice system. This course, we're going to basically cover these in more detail sorry, not this course, but a course called Pub 409 if you're in it. But the criminal justice system is made up of three components. It might be helpful to look at the very last slide of this lecture that I cover in more detail in my in-person courses. But you have the police. The police are the folks that gather evidence if they suspect you of a crime, right? So they collect and gather evidence that will be used in deciding legal innocence or guilt. They give it to the district attorney's office, which is part of the court system. Okay, the court system is where legal guilt or innocence will be decided. Okay, the court system in the United States is what's called an adversarial system, meaning supposedly you have the prosecution and the defense, right? Supposedly they are equally powerful sides and they battle it out in an adversarial process in the court, in a trial, right? And there's one winner and one loser. A lot of people, myself included, would say that's kind of more of a myth than a reality, but that's the idea of an adversarial system. It's a contest, and there'll be one winner and one loser. And the courts make a decision, guilty or not guilty. Okay, there are some weird pleas that I'm not going to get into that you may have heard of. Nolo contend. I'm not a Latin speaker, but like no contest, etc. But very, very, very important to know that legal guilt and factual guilt aren't the same thing. Okay, pretend somebody's accused of stealing a car. Factual guilt means they actually stole it, right? Legal guilt means you were held legally responsible for it. They're not the same thing. So you might, if you've been paying attention in life, you might know that occasionally the wrong person is deemed legally guilty, goes to prison, they find out later that they didn't do it, and they let them out of prison, right? So that's the difference between legal guilt and factual guilt. Our courts decide legal guilt, not whether or not you actually did it, because it's an adversarial system, right? So it's rare, but it does happen enough where we occasionally hear about it in the media that, somebody is factually not guilty, yet they are found legally guilty, and they're punished for it and incarcerated and let out and blah, blah, blah later, right? Okay, the other important thing to know is that the vast majority of criminal cases in the United States never actually go to trial. Okay, so basically the prosecuting attorney and the defense attorney meet outside the courtroom and they work out a deal. Typically, what they agree to do is the prosecutor will say to the defense attorney, tell you what, I'll lower the charge to whatever, and that only carries, a sentence of this, right? So basically they trade a lesser charge for a plea of guilty by the defendant. This can be a good deal if the person really did it, right? Because it'll lessen the punishment, and it absolutely saves our court system and thus the taxpayers a tremendous amount of money. Our court system is tremendously backlogged. That's why when people are in jail awaiting trial. Half the people in jail are there awaiting trial. Half of them have been convicted of a non-felony offense of less than a year in most instances. But basically, you can sit in jail for a long time waiting for your court date because the courts are backlogged. But it is true what my criminology professor taught me in the 1980s, that if every defendant in the criminal justice system, or even a large proportion of defendants in the criminal justice system, were to insist on their constitutional right to a jury by their peers, the court system would come to a grinding and screeching halt. I love that line. I will never forget that. So here's some stats that are consistent to every textbook I've ever read, and according to the Justice Department's own reports, basically about 90 to 95% of all criminal convictions are arrived at via a plea bargain, not being going to court before a jury of your peers. Okay, so that's just further evidence that suggests that's why the court system would come to a grinding halt if people were to insist on their constitutional right for a trial. So only if you were convicted in a court of law, meaning by the courts, I should say, because I just told you most people never have a court trial. Okay, only then would you be sentenced and sent to the correction system. Okay, the correction system basically is the element of the criminal justice system that administers some form of punishment. We've all heard of going to prison or jail. That's one punishment, but there's also fines, what's called probation, which means you could have a combination of probation and fines, but probation basically means I'm going to let you out in the public, and if you agree to be a good little girl or a good little boy and follow some rules, I'm not going to lock you up. Okay, that's what probation is. Okay. Actually, probation, that notion of I'm not going to lock you up, but you can exist in the community under certain restrictions, is the most common form of legal punishment in our correction system. Okay, so those are the functions of each of our elements of the criminal justice system. So to repeat, what do the police do? They gather an evidence. When a person is suspected of a crime, they give it to the prosecuting attorney in the court system. Okay, and then the court system is what decides legal guilt or legal innocence. Okay, and only after you've been found legally guilty would you go to the correction system, which could be prison or jail, but can also be probation and other things like fines. Okay, I'm going to introduce you to two competing perspectives. So they're sort of ways to sort of conceptualize the criminal justice system. So we're going to talk about the individual rights or due process model, okay, and the public order or crime control model. So the individual rights model is sort of the kind of idea that injustice everywhere is a threat to justice everywhere. None are free until we are all free. I actually put a quote by Thomas Jefferson on my syllabus sometimes, and it says, "A society that will trade a little liberty for a little order will lose both and deserve neither." Okay, so the individual rights or due process model, it still seeks to control crime, but it emphasizes civil rights over crime control. We want a system that enforces laws, fights crime, and keeps order, but in keeping the order and doing so, we must not trample on individual rights along the way. So this perspective sort of emphasizes the importance of the Bill of Rights that limit the power of the state. The idea here is that we need to put controls in place to guard the state from abusing its institutional power over individuals in a court of law. That's a big part of our Constitution, which are called your due process rights. Most of those were intended to protect criminal defendants from being railroaded by the state, right? Remember, they came from England, where the king, could basically do what he or she wanted, and the individual was powerless in front of the state when they were accused of crimes. And that's what sort of the United States justice system sought to do, was to limit the power of the state, in terms of they can't just railroad you, theoretically. Okay. You may have heard about Miranda rights. So when a person is arrested, the arrest isn't legal until they're read their Miranda rights. That's consistent with this perspective. Many of the rights inside the Miranda warning were not actually enshrined in the Constitution, but came about via various Supreme Court decisions. Okay, in fact, the Miranda warning has only been around since 1966 via a Supreme Court decision. But you've all heard it. It's the one you've seen on TVs and movies, right? You have the right to remain silent. Anything you say can and will be used against a court of law. You have a right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand the rights I've given you? With these in mind, do you wish to speak to me? Okay, so the whole, another idea that's come about via the due process model is the idea that if you can't afford an attorney, one will be provided for you. That's something that came about and was not actually enshrined in the United States Constitution. I forget what Supreme Court decision brought that about. Okay, but these are just examples of sort of the individual rights perspective or due process model. Okay, the other one, the public order advocate or a crime control model, that's those sort of, if you suggest when there are threats to public safety, control of these situations should take precedent over individual rights. So that's kind of the opposite of that Jefferson quote, right? Or those other quotes, right? So sort of the needs of the many outweigh the needs of the few, right? So that we have a well-functioning society and not anarchy, we may need to sacrifice some freedoms in the name of social control. There were sort of, after the terrorist attacks of 9/11, there was sort of a swing towards this more crime control model. I don't know if you guys remember, but there's this cat named Edward Snowden. He revealed after 9/11 the government had literally been vacuuming up all of our text messages, phone calls, etc., and saving them on servers, right? And that was sort of, I don't think it ever went to court, but the idea would be that's sort of consistent with the public order model, and the individual rights model wouldn't really, that would be the antithesis or against what somebody in the individual rights or due process model would think was important. So they were doing all that, much of it without a court order. So the crime control model really does suggest that we need to have crime control, but it doesn't ignore rights, right? So it's sort of saying you kind of balance the right of individual rights with crime control. Okay? So rather than limit the power of the state, this perspective would sacrifice a few freedoms, as I've just discussed. The notion that we would lower or lessen crime or our drug problems via long prison sentences is squarely in this perspective of the crime control model. Okay, let's move on and sort of balance these, if you will. Okay, let's sort of try to balance two perspectives, if you will. I think most would agree we need both, right? We do need crime control, and we do need our system to uphold individual rights. Okay, I think most would agree that we need to balance these so that we can have a fair criminal justice system. And we also need to know that the way our criminal justice system is today is not how it's been in the past. So things have not always been this way. So over time and in different localities, these concerns and these perspectives have been balanced differently. So for example, in the 1960s and 70s, we saw a lot, we saw a period where there were a lot of Supreme Court decisions that emphasized individual rights over public order ones, that whole idea of the Miranda rights. And it's also fair to say, starting in the 1980s, we went to more of a crime control model. We'll lock them up and throw away the key. I would say it wasn't until after 2010 or so that the whole idea of actually moving away from long prison sentences has started to enter our national conversation, because quite frankly it's so expensive to put away people in prison that I'm pretty much sure that all states, but at least most states, spend way more on their prison systems than they do on their higher educational systems. Okay? So when we isolate ourselves as Americans, we sometimes fail to realize there's more ways to skin a cat. For example, the American policy towards drugs has accurately been described as punitive prohibition, sort of lock them up and throw away the key. So what punitive prohibition means is that most drugs are illegal. Their possession, distribution, production carry stiff criminal penalties, right? There are other solutions to drugs which other countries take, and which the United States is starting to entertain, which is to decriminalize certain substances. So if you've been paying attention, many U.S. states now, first they start off making marijuana or cannabis legal for medical purposes, and many states have gone so far as to make it legal for recreational use, similar to how one can drink alcohol legally at a certain age. So again, these things change over time. The whole war on drugs, which started in the 1980s, is hopefully just a phase, and we're starting to realize now that, I did a whole dissertation on it, and many criminologists have agreed with me. For a long, long time we've known this, but long story short is there's finally starting to be the political will to sort of look at putting somebody in prison for long periods of time. Not only costs a lot of money, but it doesn't seem to work in terms of actually lowering crime. 95% of people sitting in prison will get out of prison one day. And so if they're super damaged by the time they get out, they're not going to know how to act on the street. Okay, so again, this is sort of speaking to how these models shift over time. There's no, we're not clearly in one or the other. We balance these sort of competing needs in our criminal justice system. Okay, this is another way to look at it. Okay, these are not interchangeable with the first two that we discussed, but think of it as another way to sort of conceptualize our criminal justice system. I apologize for that text thing. I'm going to get rid of it. Okay, the consensus model. Here we go. The consensus model. It suggests that the three components of the criminal justice system, police, courts, and corrections, are a system that more or less functions smoothly with a single goal in mind. Okay? This is a way to simplify a very complex system. Okay? And we're using this for conceptual purposes, right? Okay? So the idea is that these institutional elements sort of represent the interests of broad society and administer justice fairly and equitably, right? That's how we enforce our laws. So the consensus model, remember when we started this lecture, I said Lady Justice, right? She is sort of doing this fairly with everyone's ideas in mind, and this sort of fits in this consensus model, if you will. There's another way of looking at it, which is called the conflict model. Okay, the conflict model says that the criminal justice system is not really a system of law, but it's rather a bunch of people with conflicting goals looking out for their own interests. In this sense, justice is a product between conflicts between agencies rather than cooperation. It's not a smoothly functioning system at all, right? One example of this, if you were to say that I think it's more of a conflict model, you'd say one of the things they found in the commission after 9/11 was that intelligence agencies weren't really sharing information. They were fighting with each other. And they had these information silos. And so one didn't know what the other one was doing. If you've ever seen the movie or the TV show where the local cop is there and then all of a sudden the FBI shows up and says, I'm taking over, right? And the local cop gets all pissed off, right? And so that's an idea of sort of, the conflict between the feds and the local cops. So that would be a conflict of them. This is an idea here that the system, if you will, represents the interests of the socially powerful. Laws don't always resemble a value consensus. Okay, one example of that would be vice crimes, such as what are called illegal drugs, right? We're starting, not all people, there's not a consensus, for example, that marijuana is an incredibly dangerous drug and deserves to be legal, like heroin, for example. Okay. Tax laws, for example, are not necessarily a consensus. A lot of what we call white collar crimes are not deemed criminal offenses, but rather civil offenses, which are sort of private disputes from parties, between two parties. Okay. And I would agree, one concept of the conflict model is that these laws are certainly not enforced blindly or equally. There was this guy by the name of O.J. Simpson, who was a very famous football player, who was accused of killing his ex-wife and her boyfriend in a very brutal manner. It was sort of the crime of the century when I first started graduate school. And he was wealthy, and it was a really famous case. So he was able to afford and attracted sort of a world-class legal defense team, or sort of an all-star legal defense team, and he was found legally not guilty for the murder. I would suggest that, I forgot to mention that O.J. Simpson was African American or black. But those of us, if you were to agree with the conflict model, and I do in some instances, you would sort of say, if O.J. Simpson, there's this comedian by the name of Chris Rock, and he said, if O.J. Simpson were a black bus driver, he'd be prisoner 5792472, which sort of means a poor black person being accused of killing a white woman and a white guy, most likely, who couldn't afford a private attorney, not only a private attorney, but this veritable all-star legal team of who's who, would have been found guilty. He went to trial, he was able to afford to go to trial, and had this incredible legal defense team, and that's why he was found not guilty. If he was just a normal poor person, especially a poor black person, he most likely would have had to plea and would be sitting in prison today. Okay, so that's sort of giving you some ideas of the conflict model and the consensus model and what are they different. I think they both are useful. One lets us conceptualize the huge institutions that make up our system. The other acknowledges sometimes the system, if you will, or these elements don't run so smoothly. Okay, so this is just allows you to, I've referred to this in the very beginning of the lecture, so this will sort of allow us to sort of conceptualize the model. I'm not going to go over every single one of these, but investigation and arrest, those, I would call those turquoise colors, that's the cops. When you see pre-trial, the purple, and then below it, adjudication and sentencing, so those are the courts, and then corrections are corrections. Okay, so that might help you sort of conceptualize what we were talking. But these are basically what would happen for you to end up in prison or on probation, actually be convicted, and then what would happen to you after you are convicted. And we'll, in Public Administration 409, we go into these in much greater detail. But it's important for any criminal justice course to sort of understand the elements of the criminal justice system. Okay, that's the end of the lecture.